Okay, let's dive into this. Welcome to today's Explainer, where we're going to unpack some truly mind-bending concepts about how our brains work and how those bizarre biological quirks collide with the high-stakes world of the law. We'll be exploring a fascinating piece of research by Andrew M. Perlman titled A Behavioral Theory of Legal Ethics. If you've ever wondered why incredibly smart, well-intentioned professionals sometimes make terrible, baffling ethical decisions, well, you are absolutely in the right place. I want to hook you right away with a question that sits at the very heart of everything we're looking at today. It's simple, but it's tough. Can you ever truly be objective? Think about it for a second. When you're forced to take a side in a really high-stakes situation, whether that's a heated argument at work, a political debate with a relative, or a bitter legal dispute, do you genuinely believe you have the ability to remain perfectly, completely unbiased? Our immediate instinct is almost always to say, yes, of course I can. But as you'll see, science tells a remarkably different story. Check out these two tables. I'm going to playfully challenge you here. Which one is longer and narrower? It's obviously the one on the left, right? Well, prepare for a pretty mind-bending truth. Despite what your eyes are absolutely screaming at you right now, the surfaces of these two tables are completely identical in length and width. Seriously, no joke. If you were to trace the top of the left table and slide it over, it would perfectly match the one on the right. So why does that happen? Well, it comes down to what Nobel Prize winner Daniel Kahneman calls bounded rationality, and specifically the tug-of-war between our fast and slow thinking. That tabletop illusion totally bypasses your deliberate, analytical, slow-thinking brain. Instead, it completely tricks your fast-thinking brain. Your mind automatically and unconsciously perceives a 3D object extending into the distance, and it instantly adjusts your perception without asking for your permission. You don't consciously choose to see the tables differently. Your biology just goes ahead and makes the decision for you. And what's wild is this doesn't just happen with our vision. It happens with our hearing, too. There's this biological vulnerability known as the McGurk effect. Basically, when you watch a video of a person's lips moving to form the sound ga, but the audio is actually dubbed with the sound ba, your fast-thinking brain gets totally confused. It automatically fills in the gaps and creates an entirely new, erroneous sound in your head, usually da. Your brain literally alters the sound you hear based solely on the visual cue of the lips moving. Crazy, right? Part 1. The Lawyer's Dilemma, the Smoking Gun Document. To see how this biological vulnerability plays out in the real world, imagine a lawyer who suddenly discovers a smoking gun document. We're talking about a document that will absolutely doom their client's case if the opposing side gets their hands on it during discovery. The client looks at the lawyer and says, "Look, use every lawful method you can find to avoid handing that document over." In the legal profession, the dominant view of ethics practically demands compliance with that request. Lawyers are trained to be zealous advocates. The expectation is that they must use all lawful methods to protect the client, meaning they are actively encouraged to push right up to the ethical boundary, to go right up to the line, but simply not cross it. Sounds straightforward in theory. But we see this crazy ethical tightrope everywhere. Take the issue of client perjury. If a lawyer suspects a client is going to lie on the stand, the rules state they're allowed to offer the testimony if they only reasonably believe it's false. But they are strictly prohibited from offering it if they definitively know it to be false. Talk about splitting hairs. The lawyer is forced to act as the ultimate gatekeeper of truth, balancing perfectly on the edge of a razor.
And this brings us right to the core of Perlman's research. Let's slow down for a second to define the central, unacknowledged academic assumption that his paper is completely debunking. It's called the Objective-Partisan assumption. Essentially, it is the deeply held belief that a professional, like a lawyer, is capable of acting as a fiercely loyal partisan for their client, while simultaneously remaining perfectly objective enough to ensure their own conduct stays within ethical boundaries.
So, the crucial point is this. What if that assumption is biologically impossible? If a lawyer's objectivity is distorted by their very role as an advocate, just like your vision was distorted by that table illusion earlier, they simply cannot accurately locate the ethical line. And if they can't locate the line, they're going to accidentally cross it. They risk withholding documents frivolously or allowing perjury, all while subjectively believing they are doing the right thing.
Part 2. Your Brain on Partisanship. Lessons from Social Psychology.
Does social psychology actually prove that this objective-partisan assumption is biologically flawed for all of us? To find out, we look to social science, which is just full of well-documented cognitive shortcuts, heuristics, and biases that help us navigate a super complex world, but also regularly cause us to make unconscious errors in judgment. I mean, we all fall victim to groupthink, conforming our opinions to those around us. We blindly obey authority figures based on the clothes they wear. We suffer from confirmation bias, looking only for facts that support our pre-existing views.
Part 3. The science of taking sides. Partisanship in action.
Let's focus specifically on partisanship, the act of aligning yourself with a specific faction, party, or cause. The science actually shows that taking on this specific role fundamentally alters our perception of reality, and this brilliantly illustrates that fact. Just assigning someone to a team changes how their brain processes basic observable facts. Back in the 1950s, researchers conducted a classic study where rival students from Dartmouth and Princeton watched the exact same film of a highly combative football game. They were simply asked to count the rule violations. The result? The students perceived the game completely differently. Princeton students saw Dartmouth committing all the fouls, and Dartmouth students saw the exact opposite. Their loyalty literally blinded them to objective reality.
We see the exact same psychological mechanism at play in political partisanship. In a fascinating study on welfare policy, participants evaluated the exact same policy completely differently based solely on who they were told proposed it. Liberal participants actually favored a restrictive conservative policy if they were told Democrats proposed it. Conversely, conservative participants leaned toward a generous liberal policy if they were told Republicans championed it. The actual merit of the plan didn't matter at all. The team uniform did. The most profound finding from that policy study is this. Even though both sides drastically shifted their views based on party labels, they flat out denied it. Both groups forcefully claimed they were judging the policy strictly on its objective content. Neither side realized their own bias. It proves that our fast-thinking brains completely hide our partisanship from us. We genuinely, truly believe we're being objective when we just aren't.
Bringing the science right back to the legal field, studies confirm that lawyers are absolutely not immune to this. Just like football fans or political voters, a lawyer's assessment of a case automatically shifts based on the side they are assigned to represent. If you give the exact same case file to a group of lawyers, those assigned to the plaintiff will objectively value the case much higher than those assigned to the defendant. The role dictates the perception.
Let's step back and look at the real world to see how this builds into massive systemic failures. The objective partisan assumption causes real harm. Accountants are way more likely to approve questionable financials when auditing for their own company compared to auditing for an outside investor. Prosecutors, who deeply believe they are pursuing justice, routinely fail to hand over evidence that could prove a defendant's innocence. And civil litigators cross the line in discovery constantly. Their situational role completely distorts their view of what is fair and legal.
So, how do we fix this? Perlman outlines several behavioral solutions to mitigate these blind spots. First, we just have to acknowledge that individual willpower isn't enough. We need debiasing strategies, like actively seeking second opinions from trusted colleagues who have literally zero stake in the matter. But even better, we need to change institutional rules. For example, implementing open file policies for prosecutors where the defense automatically gets access to everything completely removes that biased human decision-making from the equation entirely.
Which leaves us with this final thought to consider. If our fast-thinking brains are biologically wired to take sides, to fill in the gaps, and to completely hide our own biases from us, can any system of professional ethics truly rely purely on human objectivity? As you go about your day, in your own career and your own arguments, I challenge you to ask yourself how much of your own objective truth is really just an illusion created by the side you've chosen to stand on.